I'm Pragya, and I bring to you excerpts from the latest issue of Outlook. One nation, one election, one nation, many people. The issue brings to you diverse debate and points of view on the idea of one nation and one election. The Legal Tangle by Amit Agarwal and Radhika Yadav. They are lawyers who practice before the Supreme Court and Delhi High Court. There is per se nothing wrong with the government of the day constituting a committee to examine a constitutionally accepted mode of implementing a policy that it considers desirable. That said, the move is certainly complex, as it seeks to depart from the existing, time-tested and fairly robust scheme of an independent and asynchronous election cycle for the centre and the states. Established jurisprudence bars ascription of motives or malice to the legislature. Good motives cannot legitimize defects or vice versa. The Constitution prescribes, under Articles 83 and 172, a term of 5 years and no longer for the Lok Sabha and the legislative assemblies of the states, unless they are dissolved sooner. Poll schedules are currently extremely disparate. At least one legislature goes to the polls every year. For synchronization, the terms of the legislatures would either need to be prematurely dissolved or extended. A consensus is now emerging that even a one-time measure would require constitutional amendments. But the problem does not end here. The Constitution would also need to be amended to account for hung assemblies, no confidence motions, and imposition of precedence rule in a state to ensure synchronity. In fact, from 1951-52 to 1967, the cycle of elections was mostly simultaneous and was broken precisely because of such events. Constitutional amendments are subject to substantive and procedural limitations. So two key questions arise. First, what will be the impact of alteration of the existing framework where the terms of the Lok Sabha and the state legislatures are designed to be independent of each other and not interdependent? Secondly, who has a say in bringing such a scheme? In addition to Parliament, do more than 50% of the state legislatures also need to approve the scheme? A draft report of the Law Commission of India in 2018 gives some semblance of the actual nitty-gritties needed to effectuate the policy. The report is still in draft form, but it has been made public to invite comments. To start with, the Commission acknowledges that even a one-time alteration of the tenure of the legislatures would need a constitutional amendment. Thereafter, the Commission proposes, imperfectly and with palpable lack of confidence, a slew of measures to address the political vagaries. No confidence motions. The Commission suggests that bringing a constructive no confidence motion should not be permitted unless it is accompanied by an alternative positive proposal to form the government. Thus, effectively a government which has clearly lost the majority of the House would be able to continue for the full term only because there is no alternative. In normal circumstances, such a House would go to polls again. The measure is designed only to prevent premature elections. Hung houses. The proposal is to give a free hand to the President or the Governor to call a political party to form the government, whether there was a pre-poll alliance or not. In case this doesn't work out, the suggestion is to impose precedence rule for the states. Midterm elections. At the centre, the Commission acknowledges that precedence rule cannot be imposed, so midterm elections are the only option in case of a hung house. But the Commission has proposed that the term of the newly elected government must be truncated so that the next cycle of elections is not disrupted. Ratification. On the need for ratification of the amendments by the states, the Commission opines that though ratification is not legally required, it should still be obtained out of abundant caution. For these and more, read the current issue of Outlook.